Hello and welcome to Resolutions, a podcast about dispute resolution and prevention. For those of you tuning in for the first time, this podcast is a project by the ABA section of dispute resolution to increase the avenues where we can connect. One of 4 hosts serve as interlocutor, engaging in conversations with members of the dispute resolution community about topics of interest in the field. My name is Caroline Stauffer, and I am one of your hosts. I serve as the community chair for the Women in Dispute Resolution and co-chair the educational subcommittee of the international section. Today, I'm sitting down with Anne Goyette. Anne Goyette is a principal of Griffiths Goyette, a leading ADR provider since 1993, resolving a wide range of civil disputes, including class actions, commercial construction, employment, real estate, and other matters. Anne Goyette has resolved hundreds of civil disputes as a full-time special master, mediator, and arbitrator through prepared and productive negotiations. She is an ADR panelist for numerous appellate state and federal courts, serves as special master and referee for more than 24 California Superior Courts, and acts as special master in national and statewide class actions. We welcome Anne Goyette in a conversation about ADR insights on strategy and minimizing risk through an article she wrote called Take 5. Welcome, Anne, and thank you for being here.
Yes, and thank you, Caroline, for having me. This is very nice.
I'm absolutely thrilled that you're here today and excited to explore the 5 steps you've developed. Your article essentially talks about navigating mediation and using a strategic roadmap. Can you share more about that?
Of course, yeah. Well, I believe that successful mediations require clear and purposeful action. And how does that translate? That translates into being well prepared before you show up for mediation. So, know your case. So that sounds basic, right? You know your case. Well, knowing your case means, first of all, verify your client's role. Before you show up for mediation, review the relevant documents. If there is a written contract, confirm that your clients, for example, in a construction defect case, confirm that your clients actually performed a scope of work that comports with what the contract documents say. I had a mediation years ago, great attorney, by the way, shows up, has a very animated argument. How can you try to blame the drywaller for the leaking windows? My guy was a drywaller. These settlement demands are ridiculous. Well, they leave the settlement conference and they've done a little bit more work before they come back again. Well, lo and behold, his client, the drywaller, had actually installed all the windows, because when he showed up to the construction site, the window installer wasn't there. His buddy was the general contractor. He says, "Don't worry about it. I'll take care of it." Well, all the windows leaked. And since the attorney had done such a great job saying this isn't a case that involves drywall, this involves leaking windows, kind of started off on a little bit of a disadvantage. He ended up doing fine in the end, but I think he would have preferred to have that information about his client. Right. So verify your client's role in the dispute before they show up. And also, in a personal injury case, do take a look at all the medical records. Make sure there's no pre-existing injuries or some sort of treatment, that the treating doctor's diagnosis for whatever the condition is kind of line up with your theory in the case. And also, I had one case that was, again, a while ago, and the parties were getting fairly animated in the discussion. It was a domestic partnership dispute. And the woman was making some claims. Now, look, I need help with support payments, blah, blah, blah. It wasn't within the family law. It was just their own private dispute. And quietly in the mediation room, her ex-partner turns to me and says, "I don't think she knows that I know that she recently got married and she's not telling anybody." Well, when I went into the other room and talked to the woman and her attorney, the attorney almost fell on the floor. had no idea about this secret marriage, and it was a key argument in this.
I can imagine.
Oh yeah. And it's embarrassing for the attorney, because each of the attorneys doing the best job they have, but they didn't ask that crucial, verifying question to their clients on some of these key factual points. And it can just hurt your position in negotiations, makes you seem a little less unprepared. So I would just say when you say know your case, I suggest verify your client's role. And along that line, also analyze the key evidence. So key evidence might be, again, the medical records, but also is there significant information or significant data that's missing that you think would move things along? So key evidence, again, personal injury, would it be helpful to have an IME before the mediation? Or when you're looking at the contract documents, are there key provisions in those documents, not just about your client's role, for example, but is there an attorney fees provision for a prevailing party attorney fees provision? Is there any sort of limitation of liability? What are the insurance requirements? Were they followed? Just take a look at all the key documents before you come to mediation. And if there's specific documents that have a direct relevant impact on the settlement discussions, attach them, or at least attach portions of them to the mediation brief, so the mediator has something to review, something substantive that he or she can discuss with the parties when they show up at mediation. Another thing about knowing your case is avoid the empty chair at mediation. You make sure all the necessary people that need to be at the negotiating table are in the room. If you show up at a mediation and someone's missing, what's going to happen inevitably is that a participant is probably going to point to the absent party as the one who should be paying the freight on the file, or at least say that, look, my contribution should be significantly less because you've got this party out here that is potentially the most liable party, and I really shouldn't be paying the lion's share on anything. And also along the same line, what's the viability of the parties? Is this a case that if you don't reach a settlement and it goes all the way to trial and there's a verdict, you're not going to be able to collect? As a plaintiff, do you have enough resources to be able to pursue the claim all the way through? And then, are you sure that you can get reimbursed at the very end from the defense? And you should also, understand the insurance picture. I did have a case years ago that went up on appeal, and the parties were questioning whether or not the plaintiff had coverage on the cross complaint, and they had done several weeks of trial and no one had kind of ferreted out that information. It ended up being very helpful to have that carrier rep show up at the appellate mediation, to get the case resolved. But do understand the insurance picture, and I always feel that the parties should know who they're negotiating with. You should know who the insurance carriers, if there are insurance carriers involved, who are they? It's not uncommon in multi-party cases that there'll be one insurance company that might have multiple parties in the case. And even though they're keeping, their distances and separating the files, it does have an impact on the settlement negotiations.
The initial steps appears to be very critical, according to the anecdotes you have given us. I mean, there's the possibility of being blindsided, but in summary, you could lose the mediation, losing faith in the process and it being quickly unraveled. So on your next step in terms of preparing your client, what are some things that you need to do?
Well, I think when you prepare your client, the first thing you need to do is define the goals. What exactly is it that your client wants? And nowadays in civil litigation, the main focus frequently is money, right? That's the main focus of a lot of the civil disputes. But oftentimes there's other goals, and one of them could be timing. A key one could be timing. So you might have a situation where your client, look, I want to fight this out, but if I could get this done by this certain date, I'll be able to sell this property to this buyer that says, you have until this time to close this deal. Or there may be litigation going in another case, and there's a pending hearing, and they're waiting for the ruling. And if the ruling comes down in favor of your client, it's a good thing, but if it comes down against your client, it totally impacts this present case. And you know what? I don't want to take that risk. We need to try to get this done by a certain date. Another one is you've got an ongoing relationship, whether it's a personal issue, a friendship, a family, or it's a business relationship, that even though you're in this conflict, you'd like to try to maintain that relationship, and you see this drawn out battle as being something that's going to cause irreversible damage. Talk to your client about the goals. There's goals that are there that may not be just about the money that's involved. There may be timing issues that will have a direct impact. And I know also, I think you should always check in with your clients, because you may have a client that shows up really angry and they're just gonna take this to the end. And then all of a sudden, the reality of litigation, the stress and the cost, and they're just saying, you know what, they could even modify their goals before mediation and kind of have a shift. Just keep checking in.
Do you ever find that clients have this deer in the headlight look during the mediation?
Not very often. I will say this. I work with I have great attorneys that I work with. And, but when you explain the mediation process to someone that's not used to it, especially if it's someone that's not in a business setting, perhaps, it just it reduces a lot of the stress and helps them realize, look, this is informal. This is your opportunity to try to take control of your dispute and make a decision about an option other than trial, right? So I think that the key thing about explaining the process, I think the attorneys do a good job. I always reiterate it when we start a mediation, just to kind of make sure everyone's on the same playing field, get things rolling, kind of lower the stress. The big thing that the attorneys do need to take responsibility for, obviously, is the confidentiality. Different jurisdictions have different confidentiality laws. And in California, the mediation confidentiality has undergone some changes in recent years. You now have to have the attorney has to have the client sign off by statute saying that their attorneys explained to them the confidentiality. And it applies, if the client later decides, I wasn't well represented in that mediation, I'm going to sue my attorney. The attorney then has this statement saying, I explained this to you. You cannot use what we talked about in mediation to come after me for malpractice. So it's just, especially since, again, different jurisdictions have different rules governing confidentiality. It's really the attorneys just make sure they explain that to their clients. I would say, Caroline, that most attorneys are very, very good at that. But it's just an important point to raise, to make sure you check that box and have that conversation with your client, preferably before mediation. And usually the mediators, again, will lay the ground rules and reiterate.
The confidentiality policy change was pretty recent. And so how frequently do these policies come? And is this something to be constantly aware of?
Yes, there have been changes. And it's a separate seminar, but there's a difference in confidentiality that applies towards settlement conferences and mediations. Settlement conferences, there's the protections that you have for confidential settlement discussions. Mediation, which settlement conferences technically under California law are not voluntary. People are ordered to show up. And so the legislatures come in and say, you can't order people to show up and then put this really strong confidentiality protection, mediation protection around those discussions, like force it on them. And in mediations, the parties are agreeing to do it voluntarily. So the the legislature has distinguished the protections that surround those different kinds of discussions. Mediation is much stronger. Settlement discussions are still protected, but it doesn't have the same depth. And I think we talked about this earlier. In my settlement conferences, when I work as a special master, the parties voluntarily enter into an agreement that they want the mediation protections to apply to their discussions.
And you're the first practitioner I've met that is not just a mediator and arbitrator, but you're a special master as well. There appears to be some distinction between these roles.
Well, special master does case management. You streamline we streamline the resolution process, working with the courts. You're court appointed. And if you're a referee, you're just, you don't do the settlement discussions. You just do the case management side. So there's a special master, a referee, both court appointed. A mediator is not court appointed. So a mediator is technically not allowed to contact the court about the case. A special master can, a mediator can't. That's just a distinction, unless the parties agree otherwise. That's always the caveat. The parties can agree otherwise. So in terms of talking about how confidentiality has changed, there's been over the last, 10 years, there's been changes in the distinction between mediations and settlement conferences, and also the confidentiality, this new provision that attorneys do have to have their clients sign a form, and the code goes so far as to lay out exactly what that form has to say. And they need to sign that before they show up for mediation.
Thank you for clarifying and providing insight into these roles. For those who are listening in for the first time, this will be pretty important. I know for me, to be completely transparent, I have not heard of a special master before. So this is very interesting, understanding the different technical things that happen during mediation, or how these contentious disputes can lead to different processes. We've gotten a little bit off topic about confidentiality and the different roles that practitioners can engage in, but I want to circle back about your step in engaging the mediator. What happens after selecting the mediator, and what do those preliminary conversations look like?
My process, we have a 4-step process, right? And the first process we call straightforward goal setting. And what that is, you bring all the parties, the attorneys engage in an initial conference with the mediator. And I like to try to use the leverage. I try to leverage the talent and experience of all the attorneys on the case in terms of how do we execute clear and purposeful action so that everyone's ready to engage in meaningful settlement discussions, right? So that may include, what information do you need in order to engage in meaningful settlement discussions? What kind of time frame are you looking at? How do you see this laying out? How do you want to structure the whole mediation process? And one of the things you do look at during that point in time is the second step, we call it, it's streamlined data gathering. So again, what information do you need for meaningful settlement discussions? Because I started off as a special master, I'm very familiar with the whole process of, getting massive amounts of documents, establishing a document depository, getting all the information. So whenever we do a mediation, we say, what documents do you need? We understand that you need a whole bunch for litigation, but what are the ones you want to prioritize before settlement discussions? Are there key depositions? Can the parties agree to a system that allows that information to be produced without voluminous discovery? You're just trying to set common goals. You're not trying to necessarily build consensus at this point. You're establishing common goals and objectives. Attorneys tend to cringe when you talk about consensus building, right?
Right.
So, and if there's one party, one of the key parties in the case, it's the target or whatever on the file, and they're claiming, we don't have any assets. We're not going to be able to pay any judgment. We're not going to be able to meaningfully participate in settlement discussions. Well, how do the parties want to deal with that? And what is the potentially liable party willing to do? There's circumstances where they might just say a declaration establishing what their assets are. They may agree to show up from an informal meeting and just put all their financial documents on the table, and people can go through them and read them and ask questions, all under the mediation privilege. I mean, there's steps you can take if the parties want to do that kind of approach to minimizing the costs of getting ready for mediation. And the other one is, simplified problem solving. Use the right experts to define the claims, clarify issues, establish defenses. Use the experts to come up with creative resolutions to the problems, other than just, the settlement discussions being all about money without any sort of other opportunity. There are a lot of solutions that you can negotiate that you cannot get in the court. You can come up with something creative in advance. And then I also talk about strategic conferencing, and that's something that I I highly recommend, once the parties kind of have laid out their common objectives, their common game plan at the front, as you get closer to mediation and the settlement briefs are exchanged, we set up one-on-one calls with each of the parties. And when I say parties, it can be just the attorneys. It could be the attorneys and their carrier. It can be attorneys and their clients. It's however the attorneys want to do it. But those strategic one-on-one conferences are incredibly beneficial. They allow the attorneys to discuss the goals, address obstacles, explore the resources that may be available to resolving a case. A really good example of how successful doing these one-on-one conferences in advance can be. I had a case where a homeowner loved their home, had been in there for years, and all of a sudden cracks just started showing up everywhere. I mean, all over the house. And he sued the developer and the general contractor. And all sorts of investigation came out, and they realized this was primarily a soils problem, that they hadn't properly prepared the pad, they hadn't properly built the foundation. And during all the strategic one-on-one conferences, these insurance issues were raised that involved soils exclusions in the policies. The carriers were not going to pay significant amounts of money that would even come close to covering the cost of repairing this home because there was soils exclusions in the policies. And these one-on-one conferences allowed me to arrange discussions with coverage attorneys and have everybody challenge whatever they needed to challenge to see if this was really a strong position. They tested the waters. We show up the first day of the mediation, and it was a one-day mediation. And by that time, the developer and the building contractor had realized, if we take this case all the way to trial, we'll be bankrupt. And the homeowner had realized, if we take this case all the way to trial, we'll have an empty verdict. And at the start of the mediation, the builder and the general contractor went into a separate room. They agreed to form an LLC to buy the house and back from the homeowner, repair it, and then resell the house. So they went into the negotiation room with this proposal. The homeowner, who was already realizing that there's got to be another option, had looked into buying a house in the neighborhood. The parties entered into an agreement. The defense bought the house back at a fair market value. The insurance carrier helped out to a small degree. And escrow closed on the sale of the house to the builder on the same day that the homeowner bought the neighbor's house. It was double escrow, and that was within 3 months of the mediation, one day. And the next day after the escrow closed, the case was dismissed with prejudice. Never would have happened.
Wow.
But that was because of the one-on-one strategic calls in advance. All these issues were identified, and there was a game plan for getting it resolved.
If you had to give a guesstimate, and you shared some of the results of if they litigated the matter, how long do you think that time would have taken?
Well, it would have been, I don't think they had a trial date yet, or if they had one, it had been vacated, but they were not imminently facing trial. There hadn't been a lot of discovery and all that done in the case. That's harder to answer these days, because even though the courts are working overtime and even utilizing video conferencing, there's a backlog. And even once you get to court for trial, I'm being told that a 4-week trial, you should be counting anywhere from 8 weeks, maybe, or longer. So to answer that in these days, I can't give you a good answer, but there are significant delays. And the courts are really trying to, they're trying to keep all the attorneys, they're doing lots of seminars, trying to keep everybody informed on what's going on, but there's a backlog. So how long that particular case was probably at least a year out from trial. But if COVID had intervened, I don't know.
Indefinitely.
I'm not going to say indefinitely, but there would be a delay.
It's interesting having this conversation because realistically, this is something that you would be discussing with the clients to prepare them for that journey. So when things start to get a little bit more complicated, do you think experts are needed, and to what cost?
I think you bring experts in when there's complex issues, technical issues or multi-party issues in the case. And experts are another expense, but if they can simplify and clarify issues and risks, claims and defenses, they're worth it. So when you bring in an expert on a case, it's not just to simplify and kind of also expand options. I'm trying to figure out the answer to your questions to what cost you would do. I had one case that the parties came in. It was a relatively small case, and they were arguing. It was over a real estate, right? And in the course of the initial call, we're setting them up. I asked them, what did you need in order to, what information do you need to have meaningful settlement discussions? And they kept going back and forth on the value of the property. And I said, well, are you willing to look at Zillow and other sites and take the real estate estimates that they list? Are you willing to jointly retain an appraiser? And we went through all these different scenarios in the initial call. And the interesting thing is they ultimately agreed to hire a real estate appraiser, and one, not three for different opinions, one. And when the appraiser came back with the one value, they said, okay, we're done. We don't need to hire you, Anne, but thank you for helping us get this going. So
wow.
Was that a cost savings? It was a cost savings all the way across the board, right?
Sure.
So if you have a very small case and you don't think you need an expert, that's fine. But if you have one that's involving a lot of money, or if there's a complex issue that, one report from that expert that can be turned around in a relatively short amount of time, why not? And when you're looking at you engaging the expert, you also should consider if you do engage an expert, how are you going to use the expert? So in construction defect cases, it's very common for plaintiff to do on how much it's going to cost to repair a project, right? So plaintiff will do a repair scope and cost and produce it to the defense, and the defense will do a reply, repair scope, maybe even cost, and then the parties have joint expert meetings to see if they can reach agreements on certain areas. Sometimes they look and say, let's try to do a joint scope, and then we'll get our own costing. Sometimes they say, no, we're going to compromise on some issues, but we're going to maintain our own scope. But the great thing about having these experts come together is you define the areas you agree on, you define the areas that you disagree on, and you get a better picture of the settlement value of the case, and it kind of narrows that gap between the two sides. Are you going to retain one expert to look jointly among a whole group of people to look at particular issues in the case? We have a case here where the parties agreed to retain an expert who was this highly respected professor to see what geotechnical issues could possibly be causing all these cracks to happen all over this shopping center. It was a very specific issue, and it can just help break the logjam. If there's a very difficult financial transaction, the parties might want to have a single financial expert sit down and kind of untangle everything, so the parties then have a better understanding of what the issues are and how they can reach a resolution. When you're also preparing for mediation, not only the preparation part, how are you going to use your experts? Are you going to share things under the mediation privilege so you can have some really open and honest dialogue? But on the day of mediation, so how are you going to use them on the day of mediation? And it's interesting because sometimes when experts show up, and you'll have each side again, they do their differing views. One expert has one view, the other expert has a contrary view. All of a sudden, that different voice, the decision maker that's sitting in the room, and that different voice, whether it's the objectivity or the style of presentation, all of a sudden they can listen and absorb the points that the attorney was been, arguing for all this time and didn't seem to get a response. Or, at the end of the expert meeting, the decision makers look at each other and realize, wow, we're in this industry and we've hired these great experts and none of us can agree. What is a jury of lay people going to do with this? Are they going to look at sound science and make a decision? Are they just going to on just totally personal bias? Sometimes it's helpful for just the decision makers to be in the room to just see who's a better presenter of the experts as well. But figuring that all out in advance before the mediation, it's a strategic approach. And also it helps you define the value of the settlement and kind of where you're willing to go. And it also helps on that BATNA we talked about, best alternative to negotiated agreement. It all comes into play. But again, that's something, if you do it in advance of the mediation, you can have I mean, you can take that opportunity to really make an impact on getting a case resolved.
So, and of course, you bring up a very important key note and actually all of the conversation about strategy. And I think this really goes to the experience you have and how successful you have been in navigating these situations and providing that to us. So thank you so much for bringing this knowledge to the table. And kind of segues into the last step where you mentioned about developing a strategy in this process.
Step 5, the take 5, yeah. Develop a settlement strategy. I mean, take some time before the mediation to kind of outline or do a thumbprint of kind of where you're going in the settlement discussions. In construction defect cases where they're multi-party, a lot of times there's these peripheral parties want to know, can we get out early? I mean, are we going to have to go all the way through, even though I was the guy that hung the shower curtain rings in the dormitories? Do I really have to go all the way through? Is there an exit strategy where I can leave this litigation early? Will plaintiff agree to settle around parties that are not engaging in their view in good faith, what they call problem parties in a case, or have taken such a strong position that the parties don't think that they'll be able to reach a global? I mean, and what's the best timing for service of a settlement demand or settlement offer? In cases involving insurance claims, oftentimes the carrier asks that any settlement demand be served 4 to 6 weeks before a settlement conference. In a wrongful death case, they might serve a settlement demand, well in advance of the mediation, but the defense decides not to serve an offer because they want the party that's been injured, or in terms of losing a loved one or what have you, to tell their story before they put any money on the table, to kind of, have it come with a more human message than just doing a settlement offer and demand. You just kind of have to give it some thought on the timing of a settlement demand and the settlement offer. And then always confirm that there'll be decision makers there with settlement authority. And when you're doing that, do take a look, who are the key players here? Are there any suspended corporations? If there are, how does that impact the entity's ability to enter into a settlement agreement? Is there any bankrupt entity? Or even if there's a juvenile involved, there's a juvenile's interest. There's just legal steps that need to be taken before those particular entities can come to the table and engage in meaningful settlement discussions. And I always like this one. I always say to people, try to be proactive. Give some thought as to how you're going to go from the start, right? Are you going to make an opening demand and you're going to have it backed up with, maybe it's a dollar figure of $1 million and $500,000 is for these defects and $200,000 is for lost rent. And are you going to do an itemized demand? Is there going to be an itemized response? Sometimes that's the starting point on some of these discussions. Maybe it's maybe you figure out how you're going to move from offer to offer based on past negotiations with your opponent. Maybe you're going to use brackets if once you make 2 or 3 moves, the parties are still significantly far apart. You're now go, okay, if we're this far apart this time, I think this is kind of what we need to do in order to create settlement discussions that are on the same playing field. Just give some thought so that you're not completely reactive in the settlement discussions, that you have your own game plan moving from offer to offer and so forth. And I also suggest, again, considering potential settlement terms. In my mediations, I ask one party to prepare a settlement agreement in advance, leaving out all the financial terms, just so that the parties kind of can see up front, like, okay, what issues are going to come up and how can we deal with them in advance? Is there going to be a mutual release? Is there going to be a confidentiality clause? Are they going to demand a non-disparagement clause? And if so, what are the legal ramifications of those? Because there's been a lot of legal decisions on non-disparagement clauses in the last couple of years. Payment security or arbitration provisions, just kind of think of that in advance. And another benefit of having a settlement and agreement in advance is that you've got all the players in one spot. If everyone's had a chance to kind of look over and agree to the terms, you can close the deal that day if you do reach an agreement, which allows the defense to close their file quicker and allows the plaintiffs to get payment turned around within a short amount of time relative, however the parties decide on payment terms. But I also think that, if you prepare the settlement agreement, a draft version, you also have an opportunity to kind of, again, set the table for how you close the deal. I don't see a downside in it. So I feel if I'm asking as a mediator, it actually helps the parties and it helps bring closure in an efficient and effective way to a dispute.
I love the part where we talked about the stakeholders being in the room that are experts. And I'm bringing that up again because I remembered a thought of reactive evaluation, what you were talking about. It's fascinating when you have a person in there and they can listen to that one person, but they cannot listen to anybody else. And essentially that's what it is you basically devaluate anybody that you've been dealing with. So because you have maybe these feelings towards them, whatever they may be. But once you have somebody who is completely neutral, and this is where kind of the mediator comes in, but more so effective when you do have an expert because they have a certain power. They have the knowledge that they've been waiting for, in terms of the parties have been waiting for this knowledge and wanting to gain more insight. And you can see that behavior where they might change and shift even physically in the role, so, or in the dispute. So this is,
and Caroline, there's been brain studies done that sometimes you can have the same message delivered, and you don't even have to have an adverse relationship with someone. It could be your attorney who's been advising you this, but you can have the same message delivered, but in a new voice, and it actually sparks different areas in your brain. So people, they're actually listening to something, even though they've had the message, they're not really absorbing it. It's kind of an interesting, they do all these studies and it's just interesting to learn about them, but bringing in that other voice can actually literally spark your brain. So
yeah, a different pathway. Yeah. Right. So interesting. And that's kind of why we do this work, is really to spark opportunity. And part of that is kind of facilitating a voice that they haven't heard before to resolve their issues. So I think it's all of this is why we do it, right? To help others see what they couldn't see before. And in terms of this process of knowing your case, being proactive, having the strategy, what are the key takeaways that you would say is important in this process that you've written up?
Communicate. Keep the channels of communication open. And when I say channels of communication, I mean with your client and knowledge of the file, with your opposing counsel to the point you can, definitely with your mediator. Engage your mediator. So, it's a great way to get to have movement on a file, on a dispute without. It's a minimal risk, really. If you can use your mediators, I want to say buffer in preparing, but that might not be the right word, but the mediators can really help you have those real-time communications that help move the process forward. And again, be prepared. I mean, just be prepared on just, this is a shot for us to maximize the outcome of this process. Take advantage of it by being prepared and doing your homework. And I'm not saying, it's not the same as preparing for trial. I'm not saying you have to button down every point, but just kind of take know your file and
be flexible.
Figure out your strategy. Like. Well, you have to be flexible, yeah, but I do think it helps to be proactive and kind of have a game plan in place before you show up, and do your homework and make sure that everybody that needs to be at that table is at that table and that they have the information they need to engage in meaningful settlement discussions.
I agree. And I want to thank you so much for being here today and talking to us about this. It's been a real pleasure, Anne. So thank you.
This has been wonderful, Caroline, and I very much appreciate the invitation. Thank you so much.